That is case number 111424 in the matter of Rodney K. Murrow.
May it please the court, for the Office of the Disciplinary Administrator, I'm Alexander M. Walczak. And Your Honor, with the court's permission, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is another case of original attorney discipline. The panel hearing was held on February the 25th, 2014. The respondent at that panel hearing stipulated to the factual allegations contained in the formal complaint, as well as stipulated that his conduct in representing 4 different clients violated 7 different ethical rules with multiple violations of each rule. The rules were lack of competence, lack of diligence, lack of communication, failure to withdraw because of a health condition. The respondent claimed that he was suffering from depression, as well as when he was failing to withdraw and protect the legal interests of several clients, as well as 3.2, impeding litigation in 3 cases, and 3.4D, and not responding to discovery. The issue on review, because the respondent did not file any exceptions, is what is the appropriate discipline in this case. At the panel hearing, I recommended that the appropriate attorney discipline was indefinite suspension. The respondent at the panel hearing submitted a plan of probation. The plan of probation was not implemented and only addressed issues regarding depression and did not cover any issues or misconduct, nor failed to protect the public, and accordingly, the hearing panel rejected the plan of probation under Supreme Court Rule 213G. The respondent then asked for censure as appropriate discipline. The hearing panel recommended that the respondent be suspended from the practice of law for a period of 1 year, and that before he's reinstated that he appear before a 219 hearing, as well as that he shows evidence that he's provided restitution in the 4 different cases. On appeal before this court and before you today, I'm recommending that my original recommendation of indefinite suspension be approved. And I make that recommendation because of the findings of the hearing panel that the respondent knowingly violated the professional duties, as well as the presence of a number of aggravating factors, pattern misconduct, substantial experience, practice of law, indifference for making restitution, as well as he made no action whatsoever to determine the loss that the 4 different clients incurred or try to remedy that, as well as what the panel commented on was his cavalier attitude regarding the wrongs, as well as lack of empathy towards the client's loss. Therefore, I ask that this court affirm the findings of fact, the conclusions of law, and the recommendation of indefinite suspension, as well as that the respondent be required to pay restitution for the injury that the clients incurred to fix the legal issues caused by the respondent's misconduct.
Any further presentation?
I have none, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
May it please the court. My name is James M. Kaup, I'm here on behalf of Respondent Rodney Murrow. And Mr. Chief Justice, if you could, I'd like to allow Mr. Murrow a few moments of our time to address the court as well, some comments that he would like to make, if that's
Certainly.
acceptable. Thank
That's
you.
granted.
As the Disciplinary Administrator's Office correctly stated, we filed no exceptions to the final hearing report of the hearing panel. Therefore, we have admitted the findings of facts as set out in the final hearing report. And also, as previously stated correctly, we have stipulated to the violations of the rules of professional conduct, and that stipulation was made before the hearing panel at their hearing in February of 2014. I would note, just in response to Mr. Wolzak's comments and his request for the original discipline recommendation from that office of an indefinite suspension, the different matters that he mentioned that came to the attention of the hearing panel, both in terms of both the mitigating and aggravating factors. He, of course, mentioned the aggravating factors in particular, but the points made on both sides, both with respect to aggravation and mitigation, the hearing panel took all of that into account. They took into account the points that were raised by counsel, the Disciplinary Administrator's Office, and came to the conclusion of a recommendation for 1 year suspension, subject to a reinstatement hearing. And we come before this court today saying that we are accepting of and take no exception to the recommended discipline of the hearing panel of the 1 year suspension and a Rule 219 reinstatement hearing.
Excuse me, when you say you take no exception to that, are you saying that you are
We are
adopting that as a recommendation
Yes.
that you would accept?
Yes, sir.
All right, thank you.
Yes, sir. We did propose censure to the hearing panel, but we thought they gave good consideration, fair consideration, both to the mitigating and aggravating factors, and we understand the thought process and the analysis that they went through and the conclusion that they reached when they came to the recommended discipline.
Where are you today on restitution?
I'm sorry?
Where are you today on restitution?
There have been, Justice Biles, there have been, of the four matters, one case has been settled. One case, or one representation was a subject matter of complaint 11861 or 11860. I'm sorry. There's never been litigation arising out of that representation. There's new counsel representing the client, Mr. Murrow's client there. There's never been any litigation commenced. There was a $2,000.
Has there been a demand in that case?
No.
Okay.
No. There was a $2,000 retainer paid, and the accounting for that showed services rendered in excess of that amount. But again, no litigation resulting from that representation was commenced by Mr. Murrow, and to our knowledge, not by new counsel either.
So is there anything outstanding?
There is the matter which is the subject of complaint DA 11775, which is noted in the disciplinary report with the initials JB. That was a representation by Mr. Murrow relating to a non-compete and a TRO that was filed. There was attorney's fees paid to him in the amount of $5,000, and that was set out at some length in the hearing panel report, the transcript there. They had JB was testified to the hearing panel. Our understanding is that the amount of attorney fees that he was paid has been compensated for out of the victim's compensation fund. I mean, just the dollar amount. It was a $5,000 payment made to Mr. Murrow and a claim made to the victim's compensation fund and payment back in that amount.
So 5,000 still owing as you stand here today?
The
To the
5,000.
victim's compensation fund, at least.
Yeah, 5,000.
Is there any other amount? that's in play?
As I said, there is a settlement, and there is a confidentiality agreement, or a settlement with respect to the individual identified in the hearing report as RD. And I think that covers it.
And what's the source of any funds under this confidential agreement? I'm trying to figure out if we do what you ask, which is to accept the panel recommendation, we're going to have to figure out what the restitution is in order for him to have satisfied it to move for reinstatement. And so if there's some ambiguity about that, then we might have a problem a year from now. If we do what you said.
Absolutely.
So I'm trying to figure out articulating what the restitution needs to be.
The easy resolution of that is to drop the restitution provision, but I don't see that happening. Mr. Justice, there is some uncertainty and I think clarification perhaps needed of the hearing panel's recommendation on that point. I think they use the term restitution of all attorney fees paid to each of the 4 injured clients is the term that's used in the hearing panel's report under the recommended discipline. I have read that to mean restitution for attorney's fees paid to Mr. Murrell by those injured clients, as opposed to some open-ended statement of any and all attorney's fees that were paid arising out of the particular representation that gave rise to the complaint.
Let me ask it this way. Since you asked us to adopt this order, what's it need to say as to restitution? Because you asked us to do it. So what's it need to say so that we all know what he needs to do in order to come back?
We don't know, standing here today, Mr. Justice, we don't know what full costs to each of these clients are, or at least to the 3 in the non-settled cases, if a claim is going to come forward, and what those clients would identify as costs incurred unnecessarily, or what they would allege to be unnecessarily incurred due to the misconduct or the rule violation by Mr. Murrell. We simply don't know that at this point in time.
So your position is that you're not agreeing to that because
I'm sorry, Justice.
So your position is that you're not agreeing to that portion of what the panel recommended because you don't know its amount. I think all my colleagues trying to get to is whether you're in agreement that he should repay whatever fees were paid to him versus whether you're also in agreement that he should pay whatever additional costs these folks have incurred because of his errors.
Certainly, we take no exception to the hearing panel's recommended discipline if it's a statement that the fees paid to the client, or fees paid to my client
by
his clients, were to be repaid as restitution as a condition of reinstatement.
Okay.
Absolutely.
And you're not agreeing with anything beyond that on restitution.
Yeah.
Okay. Thank you. That's helpful.
Thank you.
So, for example, the default judgment that was entered against one client, your client's position is that he has no responsibility for that judgment?
That's the complaint or the matter that's indicated in the hearing panel as under the initials of JM. And my understanding, and Mr. Murrell may provide you more intelligent answer than what I'm about to do. But in that matter, the defendant who had the default judgment no longer exists. It was a corporate entity that has been dissolved. And to our knowledge, there is nothing that will result from that case in the way of a claim against Mr. Murrell or a claim for restitution. There is a motion to set that default judgment aside. And since that time, again, since the time of that filing of that motion, the corporate entity dissolved. Consequently, our understanding is the matter is moot.
I don't understand why your client doesn't believe that he owes for all damages that his representation or lack thereof has caused to the clients. I'm hearing you say he just has to give the money back, but the other expenses and damages he's caused by disregarding clients is not his deal. I don't understand that.
I think that the difficulty for us is distinguishing between costs that would have been incurred by any, under any representation, by whether Mr. Murrow going forward, absent any problem, just going forward with the representation and the costs that be incurred by him or anybody else in that representation, as opposed to costs that were incurred as a result of any rule violation, meaning having to redo or undo events that occurred at a point in time. Those costs, I think, could be fairly attributable as costs that should be restitution should be made. However, we're still looking to the position we have is for restitution in the form of the client fees paid to Mr. Murrow.
So he would agree to pay the judgment, but your point is, since that default judgment was taken against his now defunct client, there's no damage to be paid.
That's our position, sir, yes.
I read the panel as being critical of Mr. Murrow not being more proactive in trying to figure out what the restitution is. And it doesn't sound like we've made much progress since the panel report. Has he made contact or made any attempt to reach out and find out the positions of these former clients? Or done anything else to try to determine the restitution?
He may contradict me when he stands before you, but I don't believe that there's been any direct contact with these individuals
Or there are
since the
new
time of the hearing
attorneys
panel.
is probably more appropriately. But.
And I've had no contact outside of the one case again that has been settled, or the one matter that's been settled, the representation of RD.
Let's talk about how any recommendation of discipline, regardless of whether it's the disciplinary administrator's indefinite suspension or the panel's 1 year, how does that fit into your client's projected life? It seems like I read somewhere in the file, and I can't quite find it right now, but something about Mr. Murrow not being interested in practicing law. Certainly the panel has made a finding that he's not fit to practice law. So from our perspective, there's no exception. There's going to be suspension and reinstate, and a required sort of showing at reinstatement, regardless of whether it's 1 year or 3 years from now. I guess my question is, what's the client's plan to go on with his life? And so how does it make a difference whether it's a 1 year suspension or the 3 years minimum that would be required for indefinite? Does that make sense?
Absolutely. It's a very legitimate question. I think like any attorney, you take considerable pride in the effort, the pain in acquiring a license and the commitment to the profession. And to be suspended at all is a painful process. I'm sure that's the case. Be suspended for 1 year is painful. To be suspended for 3 years is even more painful. It is true. Your recollection of the record is accurate. Mr. Murrow has actually moved on. He has suspended his law practice. He has not practiced the law for quite some time now. Has not taken on clients for many months. If you go to his website, you'll see that an announcement that he is out of the law practice as of May 1 of 2014. He has no legal representation at this point. His license is on inactive status. He has moved on to another career. But like most of us, he has no certainty as to what the future holds, and it is possible. We're here today because of the possibility, however remote, that he may wish to petition this court for reinstatement. I can't tell you, I don't mean to be wasting your all's time, but I can't tell you, and he can't tell you with any certainty as to whether or not he will ever seek reinstatement to the practice of law in Kansas. But he would like that opportunity, and he would like to have that opportunity sooner than later.
Any more questions? Did you have any further presentation for us? Are you ready for your client to address us?
I'd like to have Mr. Merle have time to make some comments.
Certainly.
Thank you.
Thank you. Never thought I'd be standing here. Let's touch on some of the restitution issues first. I think it got a little unclear concerning what has been done since the hearing panel. There was and again we're bound by a confidential settlement, but there was a substantial payment made regarding the RD claim. And that negotiation began in June, and I believe was resolved in late June or maybe early July. I'm not sure the exact date on that one, but it was well after the hearing panel. On the KB matter, there was an accounting made for that. There was never any further demand that I can recall for any funds outside of that. That was a case that arose out of a dispute between a daughter and her mother in a business practice, and they were seeking to work it out between themselves.
Just to be clear what you mean by that, there was an accounting, so
I was paid a retainer and I accounted for all the time that went into the exhaustion.
For the entire amount.
Yes,
So
yes.
your position is you owe no refund. to
That
the
one, as far as I
client.
understand, we're completely resolved. The one regarding JM is perhaps the most problematic because of what occurred in that case. That was a default judgment taken by an entity that vanished shortly after that. There is a motion to set that default judgment aside, which I believe, given the facts, it absolutely would be, except there's one problem. We can't find anyone to serve, and the court doesn't want to do it in absentia, so we're probably going to be looking at service by publication if there's any other way to do it, because the entity itself no longer exists. There is no opposing party. And that was where the matter was resolved when I left my practice, and I'm looking for someone who can still resolve that one, but there's not even anybody we can serve. There's nobody to set it aside against. The most problematic one in terms of resolving an amount was the one regarding JB. In that particular one, from what we saw, the claim was made for all costs of litigation, lock, stock, and barrel. And that included discovery that anyone was going to have to do, that required motions that anyone was going to have to do, that required depositions that anyone was going to have to do. And it became very unclear as to, I believe there is probably some additional sums other than what was paid. There was a $5,000 retainer paid in that case. I believe there's an accounting for all of that, plus even a little more, regarding getting the TRO in place, getting through the initial hearings, and a number of those other things. There would be undoubtedly some additional fees owed for setting aside a summary judgment that was granted in that case, but it was completely unclear from what we were given and what the demand was. What we got was basically pay for all of the litigation, lock, stock, and barrel, regardless of what was a harm. And that one became very difficult to kind of sort out because of the nature of the claim that we were given and in the amount of money that was claimed. But I would say on that one, it would be whatever, in my belief, the proper restitution would be whatever time and fees were required to set aside the summary judgment motion and get the litigation reinstated. And then from that point forward, what was required was discovered that would have been needed to have been done at any rate. So I do think there is more than just what was paid to me. It would have been whatever was necessary to get the case back on the track. But the claim we got was for everything even after that. So it was a little unclear what he was actually.
To his
I
to the
have
new attorney, or?
I have had no contact and no communication from him. This was the one, and I don't know if you recall from the file, we tried to start making a payment to him and it was rejected. We sent, if you take a look at the file, we sent a check with a letter saying we'll do what we can. going forward, and the check was sent back, and we were kind of politely told to go pound sand. And so there weren't any really other efforts made after that. We were trying to get into some kind of a payment arrangement where, and I made it very clear from the letter. In fact, I didn't want there to be some perception that I was trying to do some kind of an accord and satisfaction. So I didn't even send the check to him. I sent it to his new attorney. And so, I said, paying fees going forward, we were trying to do something like that, and our efforts at that point were rebuffed. So that one, really nothing has happened with it. I closed my practice. Mr. Kalb is correct. There is some context here that I believe is in the transcript, and this is by no means an effort to dissuade, and I got to admit, it really hurt when I read in the hearing panel about a lack of empathy. That stung, because that hasn't been the case. One of the reasons I moved on was because I don't have the ability to do anything else to help these people. The depression had reached a point. I had not billed a client in nearly 2 years. I had simply shut down in so many ways in my practice without even really realizing it. I had an automobile accident in June of 2012, and a few days after, I went down and checked the length of time of the suicide exclusion of my life insurance policy. It seemed like the most natural, normal thing in the world for me to do at that time. And to believe that some of this was intentional. One of the things that's occurred, and there's a letter from my psychiatrist that said, you've gotten better, but you ain't going to get well until you quit doing this. And he was absolutely right. One of the things that's happened since I've moved on is it's a little bit like standing right up next to a Monet painting, and all you see are the spots of paint, and the farther back you get, the more clearly you can see the picture. And that's really what's happened here. The farther this has gotten in my rearview mirror, the more I've seen how ugly things really were during that time. And it's really hard to explain that to somebody that's never been there. To say that I have regret would be the biggest understatement this court's heard today. So yeah, I had a lot of difficulty with that, and I guess maybe I just didn't communicate it accurately in the hearing or what was done. But what I moved on to was working in the staffing business and opening a staffing agency. And there's a rather fascinating story as to how that came about, but I won't take your time with it today. And it's allowing me to dovetail what I've done before. Would I want to be reinstated again? Yes, I would. Would I, at this point, do I ever foresee myself going back to the active practice of law? Absolutely not. Would I like to be able to go fix my wife's speeding ticket if she got one and appear in court? Yeah. It wasn't all awful for 24 years. I inactivated my license on my own. I told the hearing panel I was doing that regardless of what this outcome was, because I knew at that point, based on medical advice and based on everything else I was given, that that's what I needed to do, not just for me, but I wasn't going to be of any use to anybody else, my clients, my family, anybody else, until I got that resolved. So a big part of inactivating my license was precisely so I could develop the means of resolving these things. And we've done the only one that I think is outstanding is the one on JB. And again, the nature of that demand was such, it was really difficult to figure out what the dollar amount was owed. I would agree that whatever the dollar amount is, it was what was required to get the summary judgment set aside and then get the litigation on track so that a new scheduling order was in place. Because from that point forward, all the discovery that was done was everything that needed to be done anyway, whether I did it or whether somebody else did it. And I think we were looking at sort of a global claim for everything in that one. It was a little hard to sort out exactly what they were looking for. I don't know if that explains accurately with your questions and what you were looking for. I'd be happy to field any questions anybody has.
And just to clarify on JB, then you would agree that you owe the Client Protection Fund for the $5,000 it paid out?
I owe somebody. I mean, I don't know procedurally if that's the Client Protection Fund or him or who that money's owed to. Yes, I just don't know if it's the Client Protection Fund that it's owed to or it's him that's owed to. There was I'm without having the bill in front of me, I'm positive there was more than $5,000 a time put into that case. And the TRO that we obtained did allow him to go on and start his new job, and he's still there today, and that was all successful. So I don't know if I saw the response from the Client Protection Fund, and it didn't say what that was for. I don't know if that was for the amount to put the case back on track, if that was for the amount that he paid me. I don't know what that was for. I owe, somebody has probably owed some money in that case. I'm just not sure exactly what the amount is. If it's back to the Client Protection Fund, then it would be to them, I suppose. I just procedurally don't know where that.
And
where
would you
that
be
fits.
willing to accept the amount that, if they have made a determination that
Yes,
was the amount
Absolutely.
that you wouldn't question their finding?
absolutely, not at all. Not at all.
On the default judgment, I think a light bulb went off while you were talking. I just want to make sure now I understand it. You're trying to set aside, someone's trying to set aside the default judgment, but the party that got the default judgment is now a
Gone.
defunct corporation. So the client has this judgment sitting on a court record somewhere and can't get rid of it.
Right. And from what I understand, there's been no fallout from that, but it needs to get set aside somehow. I mean, they can't be collected on because there's nobody holds that judgment. Who holds that judgment doesn't exist anymore.
It's a Liz Pendens.
What's that?
It's a Liz Pendens.
Yes.
Any further questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
Thank you, Your Honor. The questions that bother this court regarding restitution were just almost identical questions faced to the hearing panel, as well as evidenced by the comments of the hearing panel that there was no showing by the respondent of any effort to reconcile or make a determination of how much, if any, injury and how much restitution he should pay. Regarding the first complainant, JB testified at the panel hearing. He testified that he incurred $32,000 worth of expenses to correct the wrong in the case. That was hiring an attorney and going through the process. Now, the respondent is correct. Probably some of that money, the legal fees, were going to be incurred in the case, no matter who represented him. But there was a significant, according to JB's testimony, amount of legal fees incurred to correct the wrong or to set aside the summary judgment. And now, the respondent also said that, at least alluded to, that he made some effort afterwards to correct the wrong to JB. Well, he did. And it's Respondent's Exhibit number 5. It's a letter dated May the 10th, 2013, where he offers to pay the JB $500. And he says, this is all the money I have. And he does not, in the letter, say he's going to pay more. He doesn't suggest that he would come up with a payment plan, but he does say that he is, quote, willing to assist at no cost in whatever way you wish to fix the problems. Now, I don't know anything about the Client Protection Fund or whether or not there's been any demand or that. That's really news to me. The JM matter, the default judgment and his motion to set aside, that occurred well over a year after the judgment was ordered. His intent, he testified at the panel hearing that he wanted to maintain his law license so that he wanted to use the law license for business networking because he's entering into a franchising, staffing business in which he wants to hold himself out as an attorney, not as a suspended attorney. It was not to practice law again, and it was not to serve the public, but only as for business purposes. Again, for these reasons, I'm asking you for the recommendation of definite suspension.
Let me ask. We have a finding from the panel that the respondent is not fit to practice law. The respondent gets up here and admits the same thing.